Hello, everyone, and welcome to the Jeffrey Epstein Show. I'm your host, Bobbycapucci, and this is Daily Drop number 122. What's going on, folks? So I have two articles for you tonight, so I'll keep the whole monologue situation short. One of the articles has to do with Courtney Wild and her invitation to the State of the Union address, which is a huge deal. And the other article has to do with Ghislaine Maxwell and Virginia Roberts and their battle over the defamation suit and which files are going to get released. Now, obviously, we hope that all the files get released in that situation, right? The more information the public has, the better, because we all understand what's going on here. We all understand that there was incredible misconduct committed by the state, by the federal government, by everybody involved who was supposed to protect people from these sort of situations. Well, all of those people failed miserably to do their jobs. So we cannot rely on investigations into the investigators by their own investigators, right? We can't rely on that. That never works out. It always turns out to be just some sort of bullcrap they feed us, some sort of narrative that they want us to believe, and we never get to the bottom of anything, just spinning our wheels and more tax dollars wasted. Well, now we don't trust you. So we want everything released to the public so that we can look at it ourselves, so that citizen journalists can take a look at it. But most importantly, so that everybody understands what the victims were saying, what the survivors were saying is the truth, right? Because these people hide behind their power to sue, their power to manipulate the courts, and they hide behind that, and they try and destroy people who come forward and accuse them of crimes. And that's been their MO forever, right? Powerful people always have done that. And this situation is no different. But now what we've done is we've pulled the curtain back and we've exposed it for everybody to see. And when I say we, I don't mean, obviously, this podcast. I'm talking about we as people who are fed up, all of us who are interested in this case, all of us who are, going crazy researching this case, following every little lead. It's because of the people that are not letting this case die. Well, that's the reason why we've been able to pull the curtain back and get a glimpse at what the magician has been doing for all this time, right? The Great Wizard of Oz. And in reality, there's nothing great about it. It is perversive, it's disgusting, and it's gross to think that these are the people that are in charge of our very lives, pretty much, folks. It's pretty disgusting. But what I will tell you is this. The fact that Courtney Wild was invited to the State of the Union is very promising. I think it's a great move. I think it's awesome for her to be able to be recognized this way, and I think that maybe it'll open the door for these girls to be called before Congress and to have their time before Congress telling their story. Because if we can have congressional hearings over baseball players who are doing steroids, then I think this trafficking ring being exposed and the stories that these survivors have, I think that it's important for them to get up there and have their chance to share those stories. And if Congress and the Senate can get involved in all the nonsense they get involved in, one would think that this would be something that they would, even more than consider. This would be something they would be jumping all over to do. So hopefully with Courtney Wild being invited to the State of the Union address, maybe that'll get the ball moving in that direction. But we're going to jump into the article here, and the article is from the New York Post. And the headline is, Jeffrey Epstein victim, I don't like that word, Jeffrey Epstein survivor will be at the State of the Union as California representative's guest. The article was written by Tamar Lappin, and it was written today, February 3rd, 2020. One of Jeffrey Epstein's survivors, who says the millionaire pedophile sexually abused her starting when she was 14, will be at the 2020 State of the Union on Tuesday as the guest of California Congresswoman Jackie Speier. And good on Jackie Speier. I might not agree with her with some things politically and stuff, but when it comes to this case, I'm willing to accept whatever allies present themselves, any allies in power who present themselves in Congress who are going to bring some more light to the situation and shine more spotlight on to what happened to these girls, then hey, I'm all for it, right? And bringing her to the State of the Union certainly does that. It certainly moves the needle a bit, and it gets people talking, so that's definitely a good thing. Courtney Wild, 31, is the namesake of a proposed bill aiming to prevent the kind of wrist-slap deal granted to Epstein by federal prosecutors in Florida in 2008. Courtney's bravery and dignity in the face of unfathomable treatment and the resulting miscarriage of justice in that case deserves and demands the nation's attention, said Representative Speier, a Democrat co-sponsoring the Courtney Wild Crime Victims' Rights Reform Act of 2019. And she's right about that, right? This girl definitely deserves some attention. She deserves to be recognized. And all of these survivors who have come forward and stood tall and said enough is enough deserve this recognition. And it might be coming Courtney's way because her name's on the bill. But this is a big win for all the survivors to be recognized by a congresswoman like this and invited to the State of the Union address. Definitely a big deal. Definitely a big deal. We are standing up for what is right and to ensure that those who continue to subvert the rule of law and those who fail to hold perpetrators responsible for their malign deeds will not succeed, Speier said in a statement on Monday. Wild, in 2008, sued the Justice Department alleging Epstein's plea deal was illegal because prosecutors did not confer with her and the dozens of other alleged victims in the case before striking the agreement, as required under the Federal Crime Victims' Rights Act. It's so insanely maddening to know that even though that this was on the books, it was a law, that they circumvented the law and they did whatever they wanted to do anyway, and nobody was held responsible. We still have Alan, I didn't take my underwear off Dershowitz being paraded around like he's this gigantic constitutional scholar, when in reality he was the one who designed this whole entire plea bargain, and mainly, in my opinion, did it with self-preservation in mind. Under the non-prosecution agreement, the serial sex predator served just 13 months in a cushy private wing of the Palm Beach County Jail, and under a work release program was allowed to spend hours a day at his office. Her lawsuit was tossed in September when a Florida judge ruled it was moot following Epstein's death at 66 in a lower Manhattan lockup the previous month as he awaited trial on federal sex trafficking charges. That's just so garbage. It was ruled moot. How could it be moot? I don't care if he's dead. Don't these judges understand? Why are they so almost like willfully ignorant about what's going on here? Almost as if they're protecting someone or people or an entity. That would never happen though, right? Our justice system would never allow for something like that to occur, would it? Would it? Wild told the Miami Herald she was nervous but super excited for the State of the Union on Tuesday. I still can't wrap my mind around it, she told the newspaper. I think it shows that we have come a long way. Hopefully, at the end of it, I would really like to give back to educate our children about sexual abuse and awareness. That's my goal. It's like giving me a second chance at life. That's heartening to hear, right? I mean, how many times have we read these articles, folks, and it's these girls' lives are just destroyed? Some of them haven't been able to even pick the pieces up. Some of them have suffered, catastrophic medical situations because of the abuse that they suffered at these people's hands. And then to see Courtney Wild here stand up and say, hey, you know what? Guess what? I have my life back. I'm getting a second chance here, and I'm going to make the best of it. And all it really takes, folks, is some people stepping up, stepping forward, some people in powerful positions to step forward and say, look, we hear you loud and clear, and we're going to really look into this, and we're going to find out who committed what crimes. And those who did commit crimes are going to face severe penalties. Whatever the most severe penalty is allowed under law is what these people should be facing. There should be no more plea deals. There should be no more slaps on the wrist. There should be no more protection. They've used all of that up. All right? We're not turning the other cheek anymore. No one's ignoring what you're up to. We're all hip to what is going on, and nobody is letting you get away with your BS. The truth must come out. All right, folks, so this next article is from the Daily Mail. The headline, Exclusive. People named in sealed documents in Jeffrey Epstein's accuser's defamation case against Ghislaine Maxwell may have engaged in sexual acts with victims, facilitated abuse, or were victims themselves, filing in battle to release papers reveals. This article was by Louise Boyle for the dailymail.com, and it was published today, February 3rd, 2020. Fresh clues about those involved in Jeffrey Epstein's sex trafficking ring have been revealed in the legal battle to unseal documents from accuser Virginia Roberts' defamation case against alleged madam. I hate that, alleged madam. She cannot be a madam if she was procuring underage girls. Okay? Underage girls or trafficked women cannot consent. She was not a madam. She was a co-conspirator and just as bad as Epstein, if not worse. The revelations came as attorneys for Maxwell and Roberts laid out a plan on how to notify the individuals named in documents and give them a chance to object to their identities being made public in New York federal court filings last Thursday. A day later, a sealed document was added to the case. On the whole, the two sides have agreed on how to inform the individuals, called non-parties to the case, with a formatted letter and a 14-day window to respond to the court. And we've talked about this before. They were, Judge Preska was talking about this, and they were putting together a format on which way that they were going to go with all of this, right? How they were going to do it, how they were going to alert people who were in the documents, et cetera, et cetera. So as you all know, I always like to provide context to the things we talk about. And anytime there's a follow-up article to something like this, something as confusing as, these court proceedings, I always like to pop another one of those articles in there to give us a little bit more of an idea of what we're looking at. Because as you all know, I'm certainly not a lawyer. I tell you that all the time. So I get confused with some of this stuff as well. All these court proceedings and rulings and statutes and et cetera, et cetera. There's a lot going on. So it's always good to add more, right? More meat to the bone so we have a better idea of what we're looking at, so we can have a more informed opinion and be able to actually have a better grip on what's going on. On the whole, the two sides have agreed on how to inform the individuals called non-parties to the case with a formatted letter and a 14-day window to respond to the court. The non-parties are those whose privacy, reputational, or other interests may be implicated by the unsealing of the sealed documents. So that means people named in the documents who were involved in the abuse or were involved in enabling it, as far as court records go, of who said what, then those people are at risk of their names being unsealed if the unsealed documents are put out into the public. There are 4 general categories that the so far unnamed individuals fall into. Some have been identified as allegedly engaging in sexual acts with Roberts or other victims or facilitating abuse. All right, so this is basically what we talk about all the time here, the different levels of sick bastards, okay? So this is for all intents and purposes, we're talking about the mafia boss, Jeffrey Epstein, Ghislaine Maxwell, and the people who were engaging in the actual abuse. That's one level, one category. The 2015 civil suit was filed by Roberts after Maxwell, Epstein's former girlfriend and consort, who allegedly recruited underage girls for the financier, pedophile, and helped him abuse them, and helped him abuse Maria Farmer. We can keep going, right? Publicly denounced her as a liar for her allegations that she was forced into sexual servitude. That's insanity. Sexual servitude? No, she was trafficked, okay? And pimped out to the other powerful men, including Prince Andrew. The Duke of York has denied those claims, and Maxwell has also denied her involvement. Others have provided discovery, fact-finding by lawyers while preparing a case, based upon the representation or understanding that the discovery would be subject to the protective order previously issued in this action. Non-parties also fall into the categories of those who intimate sexual or private conduct and described in the sealed materials, and finally, those who are alleged to have been victimized. So these are all the different people who, if they're named in the case, and they'll fall into one of these categories, all right? So the non-parties, they fall into the categories of those whose intimate, sexual, or private conduct is described in the sealed materials. So in whatever the sealed documents are, the people who have intimate, sexual, or private conduct described in those sealed materials, they might be getting put on blast here, folks. And then another category is those who have allegedly been victims. So each member of the list, which will be sealed, is to be assigned a unique pseudonym like Doe Number 1. Roberts and Maxwell have identified to the best of their ability addresses or contact information for each one of his lawyers. It is unclear how many John Does make up the list, but Judge Preska has ordered that the individuals be notified in batches of 5. So I guess it's for speculation how many people are named in the list, in the records, but you got to think Dubin, Dershowitz, Bill Richardson, George Mitchell, Prince Andrew, and several more for sure are going to be definitely named. And then obviously there's going to be names that we have no idea about, folks. When this grand jury stuff is sealed, then it's sealed. Well, we're never, that stuff never supposed to see the light of day. But if there's a release of some of these files and the information is released that we think is going to be released, there's going to be a whole new view on what's going on in this case. Maxwell and Roberts have agreed to exclude 4 categories of non-parties from the list: reporters, authors, and those involved in the literary world, police and investigators, attorneys, and medical professionals. The court stepped in to approve the list of non-parties because Maxwell and Roberts did not agree on one or more non-parties to be included in this list. So I guess the court was letting them hammer it out, and they couldn't come to an agreement. So the court stepped in to arbitrate the situation to make it so it was acceptable to both sides. Attorney Sigrid McCauley, representing Roberts, told the court that her client believes Epstein's house staff and employees should not be entitled to notice from the court because their names and associations with Epstein are public and well known. I agree with that 100%. If your name is in the public eye already and it's already been outed, I don't believe that you're entitled to the same protections as somebody whose name has only appeared in sealed documents. Now, we can argue about that law itself, but that is the law. When something is sealed like that, it is not supposed to be for public consumption. So I really hope that the court does not add these names that are already in the public view, because that wouldn't do anyone any good. But I can understand at the same time why the names that are under seal still have not been released. Now, hopefully, very soon, they have the order from the judge that gets unsealed, and we get to see everybody who was involved in this nonsense. None of the employees were victims of Epstein's sexual abuse and have not been accused of participating in that abuse. Roberts also sees no need to exclude any non-parties discussed in materials that have already been unsealed. That's for sure. If your name was in this and it's already been unsealed in some documents previously, and we know that you took part in either the enabling or the actual abuse, why do you think that you'd be getting your name sealed back up? The genie's out of the lamp, right? Pandora's box has been opened. That stuff's never going back. This isn't the old days. Everything is a matter of public record on the internet at this point. So I think it would be ridiculous to have to do that. McCauley states it would be a great burden on the court to notify those whose names have already been widely publicized and reported on who are not victims of Epstein's sexual abuse and who have not been accused of participating in that abuse. 100%. That would be so stupid. That would be so dumb. Okay, we already know this, but just forget about everything you've learned already. We're going to put these names under seal now, so let's not talk about them. Yeah, that's not going to work. However, Maxwell has argued that individuals falling into that category should be notified each time their name appears in a document that could potentially be unsealed and allowed to raise an objection. Nope, sorry, that's not going to happen. That's a ridiculous stipulation. And I really hope that the lawyers for Virginia Roberts don't cede to that one, because that's silly. How could they go about doing that? That would waste so much taxpayer money and so much time. And again, that's what they want to do. They want to run the clock out on all of this. They don't really want to litigate this. Maxwell wants to run the clock out. She's playing games like usual. McCauley writes that Maxwell's goal is an attempt to delay and complicate the unsealing process to ensure that no further misconduct becomes available to the public. It's exactly what I just said before I scroll down to the paragraph. How funny is that, huh? Great minds think alike, I guess. Sigrid McCauley definitely knows what she's talking about, obviously, because it's just ridiculous. On its face, it's ridiculous. I'm certainly not an attorney, but come on. That's absolutely crazy for that to be a stipulation. The attorney tells the judge in a letter that although both sides had mostly agreed on the protocol for contacting non-parties, we have come to an impasse on a few key issues. Maxwell has excluded 2 motions that were previously decided upon the last judge in the case from the unsealing process, according to Macaulay. In the first document, Roberts had accused Ghislaine Maxwell of failing to disclose the existence of an email account. The second motion sought to prevent Maxwell from using parts of a deposition transcript that Roberts had intended to use if the defamation case had gone to trial. Instead, the case was settled out of court for an undisclosed sum in 2017. It is not clear who gave the deposition and what it contained. Oh boy. So that's going to be explosive. That's going to be definitely explosive. I'd love to see what that is. Anytime you see stuff like that with, a transcript that would have been used if had gone to trial, then it has some significant information in it. So I'd definitely like to see what that has to say. Macaulay writes that Maxwell refuses to include these documents because they contain an abundance of critical information relating to the issues in this case that defendant does not want made public. Point blank period. Macaulay hits the nail on the head. We all know what Ghislaine Maxwell is doing, folks. We all know what daddy's little girl is up to, okay? She's trying to run out the clock. She's trying to waste time. Straight garbage. Ty Gee, an attorney for Maxwell's Colorado-based firm, provided the court with a proposed letter to send to the non-parties. The letter reads, "This case involves allegations of sexual abuse and sexual trafficking of minors. Some documents submitted to the court were filed under seal. You are receiving this notice because your name appears in one or more sealed court documents in this case." The letter goes on to alert the individual that although currently their names are in documents under seal, that documents may be unsealed in the future, which means it will be publicly available. It goes on to provide 2 options for the non-parties on how to respond. They can do nothing, as the letter states, which means their name would be at risk of being released into the public domain without their input if the court decides. Alternatively, the individual can ask within 14 days of getting the letter to see excerpts of the documents, including their name. They are forbidden to share with anyone other than their lawyer. Wow. You know what? I could see the sense in that, though. If your name is in these documents, you should get the heads up that it's about to be unsealed, and then that way you can defend yourself if that's the case, or you can come forward and provide information that might be critical to bringing the people to justice who are actually involved in this. So let's see what these court records have to say, and let's see who these individuals are. Any individual who filed objections will not be identified in the court filing. Within 14 days of getting the excerpts, they have an opportunity to object to unsealing the documents in a succinct manner and shall state the reasons for the objection. Following any individual's objections, Maxwell's and Roberts then have an opportunity to respond. Maxwell, Roberts, and any objecting individual can then request a court hearing after receiving a response to their objection. All right, I can see that. That's fair. This has to go through the process of the courts. I understand that. I wish there would be a more streamlined way for this to proceed. But if these are the steps that are needed to take, that are needed to be taken, so that the case can move forward, and that Virginia Roberts can get some justice, and the rest of the survivors can get some justice, then I think that it's just a waiting game at this point, and just gotta wind its way through the system. Unfortunately, the corrupt ass system has made it so it takes forever to get justice. Only once this process is complete, the court will set the time and date it will decide in open court the objections lodged as to each set of motions. It is then up to the court to decide whether the sealed items will remain under seal, be unsealed in a redacted form, or be released in its entirety. Then the process will begin again with the next set of motions. Yeah, that kind of scares me a little bit, folks, because how many of these are going to be redacted? I hope none of them are redacted. I hope that they're all released in their entirety. What's the point of releasing them if they're redacted? And a lot of these judges, that's what they'll do. Oh, I released them, but they release them redacted. It's kind of like they split the baby. Judge Preska, presiding over the case, has previously stated that there is a great deal of public intrigue surrounding the unsealings of the documents at issue here. Epstein, 66, killed himself, allegedly, in a Manhattan jail cell in August while facing federal sex trafficking charges. Epstein had previously been convicted by a Florida state court in 2008 for soliciting sex from a minor in a sweetheart deal given by federal prosecutors, despite dozens of underage girls accusing him of molestation. Last month, lawyers for Maxwell filed a letter to the court highlighting the risks that hasty unsealing of the documents may cause. They claim that the British socialite, aka pedophile, aka co-conspirator, aka just disgusting excuse for a human being, her personal emails had been hacked and damaging information, including the names of individuals linked to Epstein's sex trafficking case, were at risk of being publicly released. Oh yeah, okay. Again, I told you folks what I think about that. I don't believe that those were hacked. I believe that that was a shot over the bow. I believe that that was her flexing on these dudes, letting them know, look, I got the dirt. I got all the dirt on all of you cats, and I'm going to spill this tea if you people don't protect me. All right? I don't want to hear anything about these emails that were hacked and blah, 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 bull. There will be no sympathy for you, Ghislaine. Sorry, none. Not one iota. I do not care. There is zero that you could do at this point to change my mind about what you are. You are the embodiment of evil. Disgusting, gross ass, skulking around like a terrorist in dark holes as you avoid justice because you're such a coward. At the heart of it, that's what you are. A straight up coward. Attorney Tai Gee referred to details that were released in error in the 2,000 pages that were made public in August by the U.S. Court of Appeals for the Second Circuit. Despite the Second Circuit's best efforts, it made serious mistakes. For example, it redacted a non-party's name in one location but not in others, so the media immediately gained access to that name, Gee wrote. As another example, it redacted Miss Maxwell's email address, which linked to her own domain name, in one location but not another. Shortly afterwards, hackers breached the host computer. Wrong. Again, I don't believe it. Let's see some information. Let's see some proof of that. Let's see some proof that her computer was hacked. Again, everything Ghislaine Maxwell does is look at one hand while she's doing something with the other. She's never genuine about anything she has going on. Everything's obfuscation, everything's cloak and dagger, and there is zero chance that her computer was hacked. If it was hacked, all that stuff would have been dumped already. Come on, folks. The email security breach means that the 58-year-old Maxwell's emails could be sold or leaked to the public and potentially reveal more details about individuals connected to Epstein. I'd be willing to donate to some sort of GoFundMe to pay whoever hacked them if they are hacked, huh? Let's see them. But again, like I said, with Ghislaine Maxwell, there is zero chance that that's the case in my opinion. She is way too shrewd for any of this stuff. She's the epitome of what a scummy cloak and dagger spy agent is. She has all the trademarks. Just the way she is, the way she acts, the way she conducts herself, the way she treats people, the way she feels about people, and the callousness with the way she went about this trafficking ring. The clinical approach that she showed. That's not human behavior, folks. That's just straight up cold, sociopathic behavior. Okay. The Daily Telegraph reported that Maxwell used a secret mail server and not a major service like Google, which can keep emails out of the hands of authorities, but which increased the risk of them being hacked. I wonder if she had Hillary Clinton's team put together her server. I mean, I say that half in jest, but we know how close the Clintons were with Ghislaine Maxwell. We know how close they were, so maybe she gave her some tips about the old server, huh? Maybe she had CrowdStrike come in and hook her up. Maxwell retreated from public life several years ago and had been living quietly in Manchester by the Sea, Massachusetts, at the home of tech CEO Scott Borgerson, DailyMail.com revealed in August. Her current whereabouts are unknown, with Roberts' attorneys admitting at court last week that they have no idea where she is. Maxwell and others are being investigated by the FBI as part of the Epstein case, Reuters reported in December, citing law enforcement sources. So, wait a minute. So they don't know where she is, right? So what about this lawyer, Tai Gee? If she's not paying this guy anymore to defend her, or he doesn't know where she is either, I don't understand how that's going on. So if she doesn't, it's just weird to me. All right, so this Taigi definitely knows where she is. People know where she is, or it could be maybe she's just contacting them via some sort of ham radio or some untraceable way of communication. I mean, I don't put it past her. Again, like I said, in my opinion, with all the evidence that I've read, all the different avenues that we've went down, all the different dark corners and alleys that we've searched, there is no doubt in my mind that Ghislaine Maxwell is part of the intelligence community and that this was all an operation that they were running and Epstein was an asset. So to think that Ghislaine Maxwell wouldn't be able to contact from her secret bunker or wherever she is, I guess that would be kind of naive on our part at this point. So who knows, right? Who knows where this is going to go? But I really have a good feeling that these documents, at least a good portion of them, are going to be released. I just hope, and I guess that's a skeptic in me coming up with this part here, but I just hope that they're not redacted. I hope that we get a good accounting of what truly took place so that the public can really understand and see what these survivors were up against, because the hurdles that they faced coming forward and presenting this story to people, it's just mind-blowing to think about how they were discounted, how nobody paid attention to what they had to say, and when they did pay attention, how they hid the facts and how they ended up giving him the sweetheart deal and the whole entire thing leading up to where we are now. It's crazy to think about, folks. It is crazy to think about. And while there's obviously a long way to go, we have seen some movement towards the right direction. And with, just thinking about the article we read previously to this one, with Courtney Wild going to the State of the Union, Dubin stepping down, Wexner facing heavy pressure to step down, Peggy Siegel getting the boot, all these different professors that had to go, etc., etc. So we're starting to see the ramifications, and we're starting to see the fallout spread. But now, what we need to start seeing are the handcuffs clinking on. Because until that happens, until people are arrested for this, it's all fine and well to have their names destroyed and have it so they're no longer able to consolidate their power outside of the shadows. But we all know that people like this won't stop, and if they aren't punished, they'll continue to conduct whatever sort of devious nonsense they have going on, but from within the shadows. And we cannot allow it. We have to make sure that we stay on target, and we have to make sure that we keep screaming from every mountaintop that justice must be served. All right, everybody. Hope you all enjoyed the show tonight. If you'd like to contact me, you can do that at Bobbycapucci at protonmail.com. That's BOBBYCAPUCCI at protonmail.com. If you'd like to help support the podcast, you can do that by clicking on the GoFundMe link that is inside of the description box. All right, everybody. I'll be back tomorrow morning. I will talk to you then. Enjoy your evening.